Hi, welcome everyone. We'll give everyone a couple more minutes to join this Google Hangout on air with Ron Elwood. Looks like people are starting to show up. We'll give you just another minute. My name is Amanda Moore. Begin in a minute. I'm a senior attorney editor with the Shriver Center. The full name is the Sargent Shriver National Center on Poverty Law. It's a mouthful, so the Shriver Center is a little easier to manage. Okay, well, we'll go ahead and get started. As people join us, they can jump in. I think they'll be able to figure out what's going on. So welcome. Thanks again for joining us. This is our first ever Google Hangout on air with a Clearinghouse Review author. So I want to thank Ron Elwood. It's our special guest for today. He authored a piece in the July-August issue of Clearinghouse Review. That issue, we had a theme of consumer law, and he had a great piece in there about payday lending, which we'll talk about in a few minutes. As I said, I'm Amanda Moore. I'm a senior attorney editor with the Shriver Center, and the Shriver Center publishes Clearinghouse Review, which also has a long full name, Clearinghouse Review, Journal of Poverty Law and Policy. Ron Elwood, our special guest, he is the supervising attorney of the Legal Services Advocacy Project at Mid-Minnesota Legal Aid. He's based in St. Paul, so I want to thank Ron again for joining us today. Ron, you want to say hi?
Hey everybody, thanks Amanda for making me your guinea pig here. I'm delighted to serve in that role.
Well, wonderful. We're glad to have you. I'll give you a little bit of context for why we're doing this Google Hangout today. So back in January, at the beginning of this year, Clearinghouse Review became a completely online publication. So we went totally digital, took the big jump into the future. And with that, we decided that we would take advantage of some new technologies to try to create more a sense of community among our subscribers. We have this wonderful base of public interest legal services lawyers across the country, across disciplines. You know, we have a lot of local geographic kind of groups for legal services lawyers or subject-specific groups, but really the Clearinghouse Review spans all those things, and we wanted to create this wonderful community of public interest lawyers. So to do that, we thought, well, we'll have a discussion forum. So we set up a traditional discussion forum for our subscribers to use to log in with their password and username, their subscription information. But we thought, well, maybe we could do this a little more live, a little more in person to create more of a sense of community. And so we thought we would try this hangout. So Ron has been gracious enough to be our guinea pig, as he says. So I have some questions for Ron for today, but really we want to hear our viewers' questions. So if you notice, viewers, on the right side of your screen, you should have a box for questions and answers. And I want to go ahead and let everybody test that out now. We would love to hear from you during this hangout. So if you want to just type something in that to test it out, feel free. You can just put even, your first name and the city where you are, just to give it a try. So feel free. Okay, no one's responding. I know we have viewers. I can see how many of you there are down there. So please don't be shy to try this out. I hope that doesn't mean it's a technical issue that no one's responding. So somebody please do this just so. You should be able to, let's see, test out in the Q&A box. Okay. Well, I know we also have some viewers who are watching through YouTube. Whenever we do one of these hangouts on air, it broadcasts live on the Shriver Center's YouTube channel as well. Hey, there we go, Melanie. Thank you, Melanie, from North Carolina Legal Aid. It's working. Anybody else want to give us a try? When do you get a shout out on a Hangout on Air? How exciting is that? Come on. Okay. Well, anyway, we know that it's working. So if you do have a question for Ron during the course of the Hangout, please, please go ahead and send it. You can ask about his article, ask about his practice in Minnesota, consumer law in general, and I'm sure even just legal services practice type questions. Ron's been around for a while, so I'm sure he has some great tips and insights, maybe even war stories, I don't know.
Or my band, you can ask about my band if you'd like.
You have a band?
I do.
Okay, well, we should definitely ask about the band. Hey, we have somebody calling from, or watching, I should say, from East St. Louis. Jerna K. From Land of Lincoln, LAF, so that's awesome. Thank you very much. Okay, so Ron, let's go ahead and get started. I'm going to have to make a note about your band because that has to come up at some point during our conversation. But we'll start out with the serious business. How are things in St. Paul?
Things are good. The weather is not. The weather is spring-like, Indian summer. So we're very fortunate. Any nice weather in Minnesota is a plus.
I'm sure. All right, so let's talk a little bit about your article. So as I mentioned, Ron had an article in our July-August issue of Clearinghouse Review. It was called "The Verdict is In. Payday Lending is Guilty as Charged." So not pulling any punches even with the title. But I really liked this article from Ron when it came in because you hear from time to time, even among people who purport to be advocates for low-income consumers, that payday lending fills this void, that it serves this real purpose that low-income consumers need. And Ron's article just kind of goes through those arguments and basically kicks the foundation out from under them. It's a really nice piece. So, Ron, go ahead and just tell us briefly, sort of, in a nutshell, what payday lending is. What exactly are we talking about here?
These are short-term, small amount loans that are paid off in a balloon payment, required to be paid off in a balloon payment within a very short period of time, typically 2 weeks, sometimes a month. Most states that actually authorize it, and of course there's 15 states that do not, and 7 more that in some ways pretty restrict the product in one way or another. But typically they are limited in the statute to the amount of days that the loan can be outstanding. And parenthetically, that's one of the, as I'm sure all our colleagues on the Hangout today and all across the country know and deal with, the whack-a-mole problem. You create some sort of restriction and then there's a loophole, a workaround. So for example, I know, and I believe it's in Illinois, if I'm not mistaken, Jenna, you tell me if that's right, but my understanding is, so the law was passed and it had to be, it couldn't be any more than 120 days, and they make the loan 121 days and say we're not subject to the restrictions of the statutes anymore. So a payday loan is just, the ultimate subprime product. I mean, is the definition of a subprime product. Extraordinary interest rates, no real underwriting done at all, ability to pay, evaluations conducted, and it's got a long history in America. But it reemerged, as most folks probably know, in the 90s again, with some fella down in Tennessee who thought that he could make some money by lending small amounts of money at extraordinary interest rates for a week or two, or 2 weeks, or a month, and it has ballooned into a multi-billion-dollar industry whose tentacles have reached, as far as the Caymans.
Well, thanks. I should note I'm in Tennessee now, so it's always nice when we can have credit for something like that. So we always get so much good press. But Ron, one of the arguments people say is that really it's just a bridge loan. That's all it is. It just gets people from a short period of time to a period of time when they're going to have a bit of income. What's wrong with that?
Well, you know, that's the party line of the industry, and the fact of the matter is that it is no such thing. It is advertised, marketed, sold politically as that, but in fact, when you strip away the rhetoric, both the design of the financial product, its utilization, and the industry's own business plans, actually, it's just the opposite. The industry has a website called the Consumer Financial Services Association, CFSA, and if you Google that and go on that site and they talk about you know, use of the product, it says this is a quote unquote financial taxi. To get you from one crisis, you know, get you through a crisis or over a short bump in financial bump. But the fact of the matter is that the predominant use of the product is repeat lending and serial borrowing. And it makes sense because when you think about it, if the only ability to pay standards that if they employed at all are what percentage of this borrower's income is the maximum I will lend against. So in Minnesota, for example, some of the lenders have put a self-imposed, we're not going to lend more than 25% of a person's income. But if we're talking about, by definition, people who need a payday loan are on the financial bubble, on the financial margins. They're the most financially vulnerable. They clearly don't have enough money to make it through to the next payday. So they're going to take a quarter of their salary, which is meager to begin with, and not enough to meet their expenses, and borrow against that. And is there an assumption that there's going to be more money in the next payday to not only take care of the loan plus the exorbitant interest and then plus meet their expenses for the following 2 weeks? It's designed to force people to continue to take one loan after the other to basically pay off the interest from the loan before. So if you do the math, in Minnesota, for example, the way the interest rates are structured, if you took a $450 loan, by the time you took 10 loans, which is the average number of loans that a borrower takes in the state of Minnesota, and that's consistent across the country, you would have paid $800 to borrow $450. Your interest would have been exactly the same as the amount that you borrowed. So by design, these things are intended to trap people in the quicksand that they can't get out of. And then the second thing I'll just point out is that when some of these folks in the industry they do these conferences, as of course we do and everybody else does, and there was some information that emerged from one of these industry conferences where the CEO of one of the biggest lenders in the country, national lender, said the idea is to get people in and keep them in there borrowing forever. So that's the deal. They can't make money if it's only a couple of loans. The only way they make money is by getting people in over their head.
That's a pretty damning statement there. Well, I want to encourage, if people have more questions about your article or about payday lending and some of the myths that surround it, I want to encourage people to submit those questions through the Q&A feature on their screen. I want to move on, though, and talk a little bit more broadly about your work. So you are with the Legal Services Advocacy Project of Mid-Minnesota Legal Aid, and I want you to tell us a little bit more about what that is. What type of work does that project do?
Mid-Minnesota Legal Aid is one of the legal aid programs in the state of Minnesota. I think we're unique in the sense that most states have one legal aid program, or maybe an eastern or western, the states divided into two. We grew up in Minnesota providing legal services for low-income folks regionally. Over the last 100 years, and so we actually have 6 independent legal services provider programs. They're all separately, they're separate nonprofits with their own boards and EDs, but working together in a large coalition. And the Legal Services Advocacy Project is housed within one of them, Mid-Minnesota Legal Aid, which stretches across the center part from Minneapolis out across the center of the state. And 37 years ago, a small group of attorneys formed the Legal Services Advocacy Project to do legislative advocacy at the Capitol, policy advocacy. Obviously, we have hundreds of lawyers that do individual case representation and advice, and there are 3 of us here at the project that go up to the Capitol and advocate on behalf of all our clients on big public policy issues and trying to make the systemic difference. And I see James has a question.
Yes, I see that. So we have James. Thank you for your question. It's following up on the payday lending, so we'll jump back to that for a second. James is from Chicago Heartland Alliance Policy and Advocacy. He wants to know if states that have tightened up on payday lending, have those states seen a surge in auto title lending? Did it just shift to a different format?
I have seen no data or anything on the national listservs or any indication, any evidence that that has actually occurred. I know there are a number of states and a number of lenders. One of the big ones that has come in here several years ago and is across the country, Ace Cash Express, provides both payday loans and auto title loans. So I guess the short answer to your question is I haven't seen anything that indicates a correlation where one goes down, one tightens up, and then the other surges. But that doesn't mean that it's not happening. I just don't know of any evidence to suggest that it is.
Okay, well, thanks. And again, feel free, any of our other viewers, to submit questions. Thanks again, James.
Yes, thank you.
So back to your work in...
Well, there's another question that popped up.
You're right. Also, what do you think are the key components of payday lending reform? Right. What's the best way to go about nipping this practice?
Well, I think the number one thing that actually goes to the heart of it is creating responsible underwriting standards. Because the fact that the most egregious part of this type of lending is that it's as I said, it's a subprime product. It's the poster child. You go in the dictionary under subprime lending, and there's a payday loan, and I mean it is the ultimate subprime loan. And if we've learned nothing from the foreclosure crisis, what we've learned is providing credit to people who don't have the ability to repay is the most egregious form of irresponsible lending, and not only harms individuals and families, but in that case almost brought down the whole economy. And so what I think is the heart of it is the payday loan in and of itself, if used the way marketed, and if used occasionally, nobody would complain about it. People took 4 payday loans a year, perhaps, or something like that. Nobody would care. But they can't make enough money to stay in business at that. Therefore, they need the repeat lending. But the bottom line is, the borrowers who are feeding the beast are the ones that cannot afford to repay and that are worse off under any circumstances after getting involved in it. So if we could say that there's got to be, just as the national banks were just slapped down by the OCC and the FDIC from providing the payday loans through their advance deposits through the ATMs, and they were basically doing payday loans by another name. And those 2 regulators just did exactly the same thing and said you must conduct an underwriting analysis looking at income and expenses to make a rational determination as to whether or not this borrower has the reasonable ability to repay the loan. If you do that, well, 2 things would happen. First of all, you'd get people into the product that actually have a reasonable chance of not getting stuck in the quicksand and actually using it the way it's purported to be. But honestly, if you did it, you'd probably drive the industry out of business, because their lifeblood is to deal with people who actually can't afford to pay it back, so they have to keep taking it over and over again. So underwriting standards, doing a reasonable, rational underwriting standard, or responsible underwriting standard, I think is the number one reform, and it is actually the most defensible, because, I mean, it's very hard, I think, for any financial institution or any lender, especially a subprime lender, to argue that we should not take into account the borrower's ability to pay before we lend the money. The second reform, there are two other ways to attack the problem. One is a rate cap, and one is a loan cap. And the rate caps issue, many states have done that. If you do that, you drive them out of business, because folks on the Hangout may know that the Military Lending Act in 2006, I think it was actually signed in 2007, put a 36% cap on payday loans and all sorts of short-term lending and a variety of loans to active duty military personnel and their families, to address what the Department of Defense saw as a scourge of payday lenders surrounding, around military bases. And so that has tamped down dramatically as a result of this 36% interest rate cap. And just parenthetically, you might want to know where the 36%, why did we pick why do advocates pick 36%? Well, it actually stems way back into the turn of the century, when there was these salary lenders that were the predecessors of the payday lenders. It's the same thing. We'll lend you, some money against your next payday, and you got to pay me back, this pretty exorbitant interest rate. An outcry for reform in the teens came about. The Russell Sage Foundation actually led the charge, and they created a uniform loan law which was curbing these kinds of practices. And it was that uniform law that established that 36% is about the most that, as a society, we want to tolerate as an interest rate. So that's where that actually came from. But it's been adopted now again in the 90s and through the 2000s and up to today as the 36% or less. And so many states have done that, and that has driven them out. Capping interest rates in Minnesota, for one state, maybe in other states, is politically problematic for some. There's a reluctance among some legislators to actually regulate prices. So other states, Washington and Delaware, for example, and we tried it last year, we were this close, we just missed it, but to put a loan cap. To suggest that, for our data, and data across the country are suggesting that 10 loans is average in Minnesota, and I think this is probably consistent around the country too, a fifth, 20% are taking 20 or more loans out per year. So you're talking about somebody, indentured to the payday lender, chained to the payday lender for the whole year. So if you suggest that, well, to break this cycle, putting some sort of a reasonable cap, I mean, how many emergencies can you have? I mean, obviously, low-income folks, every day, I mean, they're facing some kind of emergency. But if you're purported to be a loan to help you to fix the car, well, you can only fix the car once, and then 12 months later, you're not using the money to fix that same problem. So, there is some defensible argument to suggest that, putting a rational loan cap. Washington has 8, Delaware has 5. The lenders will argue that that puts them out of business. They can't. You're dipping into we just can't do it. Well, that's baloney, because actually in Washington State, the lenders are still lending. The same lenders who lent before are still lending. Yes, they're making less money and they're making fewer loans, but people are still using the product, and arguably they're at least in some better posture not to get caught, not to take 1 step up, 2 steps, 3 steps, 4 steps back, but at least try to tread water until they can get ahead.
Thanks, and thanks again for that question. That was a really good, nice, practical question. If you have more questions about payday lending, feel free to shoot those in. We're really cutting close on time. This half-hour lunchtime hangout has gone by pretty quickly, and I don't want to leave without asking you about your band. So can you tell us, what's your band, Ron?
Well,
Does it have to do with payday lending?
It has nothing to do with it, actually. I do play I play drums in one of the Twin Cities Grateful Dead tribute bands, and the name of the band is called Not Quite Dead. Works on a lot of levels.
Right. That's a great name.
Yes, we have a gig this Saturday night, so if you're in town, give me a call and I'll direct you to the venue.
Excellent. All right, so watch out for Not Quite Dead.
There you go.
Greater St. Paul area. Okay. Well, we only have a few minutes left. I do want to ask one more substantive question. What are the next big policy challenges that you all are looking to tackle?
Outside of the payday lending arena, are you asking?
Right. Aside from that, what else is in your sights?
Well, the most immediate thing that we're working on for the coming session is, well, there are two things. There's a sort of a macro issue and then also a more discrete issue. The discrete issue is trying to tackle medical debt and medical debt collection practices by the nonprofit hospitals that provide the services here in the state. We had a pretty egregious case a couple of years ago where one of these nonprofit hospitals hired an outside collection agency, and actually they were shaking people down in the emergency rooms before they would even, while they're waiting with their broken arm or whatever, bleeding, and they're being shaken down to pay up the money. And it was just ludicrous. And so we want to kind of put a whole set of requirements and prohibitions about letting people know what kinds of charity care is available, medical assistance, that kind of stuff, before you start, getting them into high-cost credit card stuff and all that business, and just the kinds of practices that hospitals should have a lot more accountability for the debt collection practices of the collection agencies they hire. So that's the discrete issue. The larger issue is not unrelated to the payday lending issue. The fact of the matter is people do need short-term, small amount loans, and they can't get it from the only place they can really get it is from these fringe, predatory, unhealthy, irresponsible types of lenders. And so the reality is that even, the push for years was to say, oh, let's just get these folks hooked up with mainstream lenders and everything will be fine. Well, what we've learned, I think, is that, there's a segment of our population that is, the mainstream banking system, financial system doesn't work for them, so their choices are between a mainstream system that doesn't work for them and that also is fraught with problems, overdraft fees, and all sorts of problems, or these fringe financial service lending products, which are just as bad, if not worse. So the problem is we don't have a system we don't have a third way. We don't have, there are the CDFIs and those sorts of things, the small responsible lenders, the nonprofit lenders, but the scale is so small that it doesn't really make a difference. So the thing that we're going to try to focus on over the next couple of years in the macro is actually creating a third way that's scalable and competes with these two institutional lenders that really institutions that don't work for the populations that need the service, and to move them to financial stability. And it's a daunting and ambitious task, but I think there's starting to be a critical mass of understanding that the status quo just does not work, and we need to do something different. And how that happens and where the financing comes and how sustainable all that is are all questions we're going to have to address and answer. But I'm always of the belief, where there's a will, there's a way, and I think we need to build the will, and we'll figure out the way.
Well, that's a great note to end on. Good luck. I want to thank you again, Ron, for being for hanging out with us today. This has been really nice. I've enjoyed it. And thanks for your questions today, and to our viewers. I want to let you know, if you have more questions and maybe you'll think of them later and you would like to ask Ron, we do still have the discussion forum open on the Clearinghouse Review website. You can find the discussion forum link there, and you'll see the link to Ron's discussion forum. You just have to use your Clearinghouse Review login and password to access that, and we'd be happy to take your follow-up questions there. Sort of on that note, because this was our first one of these, and we're thinking, maybe this would be something we should do with every issue: highlight an author, have a lunchtime hangout with them. If this is something that you think we should continue to do, please feel free to let me know. If you think it's not something we should continue to do, feel free to let me know. My email address is Amanda Moore, it's M-O-O-R-E, at povertylaw.org. That's all together, Amanda Moore and Poverty Law. So let me know what you thought. We're always willing to have to listen to feedback from our subscribers. And I'll just alert you, the next issue of Clearinghouse Review will be coming out in the next couple of weeks. It's our September-October issue. It will have a theme of affirmative advocacy, which actually Ron was talking quite a bit about today. It should be a great issue. It's got a lot of good stuff in it. So look for that. The table of contents with links to the articles should arrive in your email inboxes on Tuesday, October 14th. So be on the lookout for that. Thank you again, Ron, and thanks to our viewers. I hope you all have a great day. Thanks.
Thank you.